So we're going to be talking about the secret courts in the UK. It's actually, when we're saying secret courts, it's not exactly what you would imagine, like someone taking you away and then like trying you in a cellar somewhere. Like that's not what it means.
Oh, hang on! Thank God.
Yeah.
Thank God. It's not quite Nazi Germany, right?
It's not. But
good minimum standard. Let's move on.
But it's the Justice and Security Act of 2013 that should be on the screen right now. Maybe not.
Mm-hmm.
But it basically expanded the use of closed material proceedings. That's a kind of a thing that's been on the books since 1997, I think, and it basically says that you can, under certain circumstances, you can use evidence in secret, so that it doesn't get so it's not revealed to the public. And the act in 2013, the Justice and Security Act, basically expanded this. I'm going to talk about the details in a minute, but it basically expanded this from very specific examples, very specific situations, to basically any civil courts and any civil case. And so what exactly do closed material proceedings mean? It means that some of the evidence or all of the evidence is hidden from the accused. So the accused doesn't know anything that the prosecutors, the state, is saying against them, and there's only a special advocate, quote unquote, that's allowed in to hear this evidence. But the special advocate is someone who has a license to be there at that spot, and he has no real connection to the accused. So the accused is basically just being, quote unquote, represented by some guy who he'd never met and who doesn't represent his case and is not his lawyer. I get a summary from Open Democracy, where they say what actually means these proceedings. The civilian and their lawyer cannot be present during those closed material proceedings, cannot see the evidence the government is relying upon, and which is said to be national security sensitive information, cannot see the government's case on this evidence, cannot challenge this evidence on the government's case, and cannot know the reasons for the judge's decision on that evidence and therefore their case.
So this person who has been accused isn't. I mean, they're allowed to know the accusations. Or? Okay, so can they face their accuser? Do they know what the accusations are?
They know who the accuser is. It's the state. But they don't know what they're being accused of. Right. Not necessarily. They can, if that's not the sensitive information. But if
they're lucky, they can find out what the evidence against them is.
Yes.
But they can't challenge that evidence.
No, because they don't know what it is.
Right. It just sounds like the sort of thing I would expect in the Soviet Union.
Yes.
Like, I'm thinking of that meme that comes to mind. You've been accused of crimes against the Soviet state, blah, 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 blah.
Yeah.
Like,
I
you are
guess,
found guilty and now sentenced to death.
I guess. Okay. And how frequently have these been operated?
Oh, well, that's the thing no one actually knows, because...
Oh, Jesus! Right, okay.
So I've got another quote here that's from True Public as well.
Yeah.
It says, the article, just to make it clear, the article is from 2015, but they're quoting the concerns from 2013 when the law was being passed. So, quote, "This law, when passed, as it will be, can then be applied to all and any offence, even as lowly as a traffic accident. Accused persons will never be told what they are charged, and of course, it is very unlikely that they would be found not guilty." And then they continue that by 2015, no one was able to know which cases are actually being tried in this way. And so basically, the government doesn't tell you in any statistics how prevalent these actually are when these are being used. Of course, when a single case gets publicized, then it is public, but you can't see that from any statistical reports or anything like that.
So if there were 50 this year, but only one made it into the press or something, then
you only know about the one. Yep.
I'm just speechless that this is what we allow to happen in this country.
Yep.
I mean, this genuinely sounds like something that the communists would do, or the fascists would do, in the 20th century.
There's the thing, you're just hoping that the guys in charge of it aren't going to use it for traffic accidents, and instead are only going to use it for very serious terrorism.
Imagine if, let's assume that the Conservatives are just benign and useless, right? So that they just, right. So so they just have no particular intention of using this. They just want to protect state secrets, apparently, as if anyone gives a damn about Britain's state secrets anymore. But let's assume that they
do, because it's part of Five Eyes.
Oh yeah, good point. But anyway,
I'm going to get to that in a second.
But
as well.
just the fact that this is all an accountable power that is just there for the taking, when a Labour government is probably going to be the next government we get. And do I think that Labour are beyond doing things like this? No, I do not. This is a worrying thing to hand down for posterity. I mean, aren't they worried that there might be some sort of giant far-right backlash in like 10, 15 years where, the new version of Hitler gets elected and then he's just got this wonderful array of tools with which to persecute his opposition?
There is no far right in the UK that's ever going to get into government, only far left.
Well, you say that now, but you don't know what in 10 or 15 years things will look like.
I found that a lot of these people are not thinking in this systemic way. What's important is basically how you maintain power, right? And so you don't think about the scenario where you don't have power, because what you're concerned with is how to preserve it, right? And so you don't hedge your bets by doing something that is not great for you, but not awful for you in the future
I
either.
understand the thing that they're doing, but I guess the point I'm trying to drive home is they have a moral responsibility to think about what they're going to be passing on to the next administration, and the one after that, and the one after that.
I agree that it's way more responsible to think that way. I don't agree with them on that at all. But
sorry, go on.
Yeah. So how these closed proceedings are justified is on the basis of national security. And so the phrase national security is like an all-powerful thing that can be used for anything. We covered a few days ago, so go check that. If when a bill that is being passed now that allows criminal conduct for secret agents, and that's part of it is also national security reasons. So this is a phrase
Everything
that's
can be
involved.
justified under this,
That's being involved in everything. And so, according to the Justice Gap, quote, legal cases from World War I through to World War II into peacetime decisions and beyond have shown a remarkable consistency in the positions taken. Where a government official spoke the words national security at trial, the evidence in question would usually be understood as and accepted as inaccessible. And so that's in the context of the UK, obviously, that this has been basically the way in which these things have been dealt with, even before 97, when they actually were written as law. And so this has been a long-standing kind of trend that these national security concerns, things that are portrayed as sensitive, are are then given like an upper hand in these. But the standard that is used for other cases is not then used in that context.
Yeah, but this sounds like the sort of excuse that was given during the Iraq War to hide what were war crimes.
Yeah. I mean, and
terrifying. It's bad.
It can.
It's the yes meme.
Yeah.
It's like, you're trying to hide war crimes. Yes.
And if you actually read the concerns and read the scenarios that people have proposed that can happen under this law, it's exactly what it can do and what it probably does, even though we don't know about it, right? And so in that vein, I wanted to read out one of these stories. The first part is an actual case that happened. It's adapted a little, but it's basically what happened. And then the other part, I'll let you know when, is fictional. And this is a scenario. This is an article that was written before the law was passed as part of a campaign against it. And so the second part will be an imagined scenario that could happen under the law where it passed. And it was passed, and it probably happens now. So it's about a man called Hassan. He's from Libya, and this is his story. So Hassan had been a prominent spokesperson against Gaddafi in Libya. He had been forced to flee Libya in the 90s and had originally lived in the UK. He had then lived in the Far East with his wife. He and his wife had been living in Kuala Lumpur for some time. One day in 2004, they were both arrested when trying to travel back to the UK. Hassan was held separately from his wife and not given any information about how she was or where she was. She was pregnant. Hassan was kept for days by the CIA. He was mistreated and beaten. He was transported to Libya and handed over to the Gaddafi regime's security services. He was held for nearly 2 years at the prison. While he was there, he was tortured. There was a trial in Libya, but Hassan was not allowed to have much to do with it. At the end of the trial, Hassan was sentenced to death. That's how most trials worked at the time in Gaddafi's Libya. While Hassan was back in prison, Gaddafi was overthrown. Hassan then became an important figure within the new government. In September 2011, during the chaos as the Gaddafi regime collapsed, a British journalist found papers in a building which had been occupied by the Libyan security services. These papers included an email from the head of the British Security Intelligence Service MI6 to Gaddafi's head of the spy service. The email mentioned Hassan. It said, quote, "I congratulate you on the safe arrival of Hassan. This was the least we could do for you and for Libya to demonstrate the remarkable relationship we have built over the years. I'm so glad. The intelligence on Hassan was British. I know I did not pay for the air cargo, but I feel I have the right to deal with you direct on this," unquote. Hassan had already started his case against the British government, the head of MI6 and the foreign secretary when this email was found. And so this is the facts of the case, what actually happened, and this guy then went on to basically have this case against them and was allowed to have this case against them because it happened before 2013. And so now what I'm going to read out is a fictional continuation of this story if it happened after the bill had been passed. After the passing of the act, Hassan's case was made the subject of the close material procedure, CMP. Hassan's lawyers explained that the legal test for whether a CMP was allowed was not very strict. Hassan's lawyers said that the government were allowed to use material which was irrelevant to the issues in the case as the basis for its application for a secret hearing. So the government could have been telling the judge about the intelligence information they had from the source in Kuala Lumpur that gave details of how Hassan was suspect of being, quote, dodgy. Hassan was told by his lawyers that the judge had ordered the British government to give Hassan a summary of the material it wanted to rely on in secret. The British government had decided not to give Hassan or his lawyers the summary of the material. There was nothing Hassan could do about this. A security-cleared lawyer was appointed to speak to the judge about Hassan, but she had no responsibility to Hassan's interest. Once the special advocate had seen the evidence which the defendants were relying on, she couldn't speak to Hassan about anything to do with this case. Hassan's lawyers explained to him that it was not possible for him to know what material was being relied on by the government in its application for the CMP to be used in his case, or the evidence introduced under the CMP. Hassan's lawyers had explained to him that this was the situation. Hassan personally found it difficult to see how a lawyer could possibly do anything for him when he himself didn't know anything about what was being said about his case in secret and couldn't tell the special advocate anything at all. Hassan lost his case.
So that is what could potentially happen.
That's what people were worried as the law was being passed in 2013 that could be happening. And
now the law is passed this year, last year?
The law was actually passed in 2013, back then. Right. And so I would urge people to go to this article because this is one of the 8 scenarios which they propose could happen under this law. It's an article by Open Democracy, and we'll leave it in the description. And so this was something that they thought might happen, and it's something that is probably happening now a lot, but we don't know about most of these cases because it all happens in secret unless someone really digs into it.
Oh, that's good news, isn't it?
So, just to understand, so if you want to get someone out of an area, let's say British intelligence wants some guy out of Libya or something, but then they decide, nah, let's just get rid of him. Yep. They could make up some evidence and be like, oh, he's a shoplifter.
Yep. And
then present it to the judge and then say that's got to be secret evidence. Hassan doesn't even know that he's being accused of it. And then we throw him into a jail cell.
And no one can review whether the evidence is true or not because it's being secret. So the only people that can actually review it are the accusers and the judge is not going to do anything, right?
Does this apply to citizens as well, or only foreigners? Everyone. So this could also apply to a British citizen if...
Yes.
So what you're saying is Ian Blackford could actually persecute me now?
Yep.
God damn.
I'm trying to think what he... So he'd accuse you of breaking COVID restrictions.
Yeah, I guess he would.
Have you arrested, and then the secret court would be like, nah, we don't need to tell you anything about
national security concerns. Sorry. You're in jail for 2 years or however long. It's like that's...
Exactly. And national security concerns could be something tied to you crossing the border into Scotland because that's the border, so it's national security.
I guess it is.
Plus, we've been seeing your online content and you're an extremist, therefore.
Well, yeah, that's what they would say. But yeah, so welcome to 21st century Britain. Yeah. It's not free. It's not a free country. Incidentally, I mean, what was the update on the COVID rules? Can't we have like a 3-family get-together this
So,
Christmas?
Yeah.
Christmas. 3 households are allowed to collectively create a bubble. So you're allowed to interact with 3 households at Christmas. So I could bring my parents and, I don't know, some siblings, right, to my house, and then we could all meet. But you could do that, as I understand, with any country in the UK.
Oh, wow.
So you could bring down a family from Scotland or Northern Ireland.
So I can
How
invite Ian
generous.
Blackford over for Christmas.
Yes, you can. Or go visit him.
Yeah. So to just continue with.
Oh, sorry,
with,
yeah.
I didn't know you're done.
Yeah.
No. It doesn't get worse this time. It just continues on. So the EU Parliament actually made a report in 2014, doing like an international comparison of these practices, and so they looked at 8 countries, I think: Germany, Italy, Spain, Sweden, I think Netherlands, and UK, and some other. And they said that basically the UK had the strictest rule since 2013 about this. Some other countries have the same rules or similar rules, but they are not as widely used. They can't be used in all civil cases as it is in the UK since 2013. And so the report says, I quote, "The study demonstrates that secret evidence is not always legal evidence. In countries such as Germany, Italy, or Spain, the rights of the defense and the right to a fair trial cannot be, quote, balanced against national security or state interests, as this would directly contravene their respective constitutional frameworks," unquote. So in some of those countries, the constitution actually prohibits this being used as evidence. It can be something that you can be accused of, and it can be something used in trial, but it's not up to the standard of the evidence
it must
that
be
is
nice
actually
to have
considered.
a constitution, mustn't it?
Exactly, that kind of supports your argument
Yeah, it
from
does.
earlier.
It does.
And so another quote says, "In some EU member states, the constitution expressly forbids the use or framing of intelligence as, quote, close evidence before the courts, as this is considered an unacceptable interference with the rights of the defense, the principles of open justice and adversarial proceedings, and the democratic rule of law," unquote. So that's basically what the EU was concerned about. There's also another angle to this report, which is basically that the report pushes for overarching EU rules. That's what they do all the time. They take something, say it's wrong in this country and that country, and say the solution is to centralize it, which is not surprising, but the report is still valuable in that it gives the information about what the individual member countries actually do. And so I wanted to also mention some defense of this, right? Because almost everyone was against it when it was being passed in 2013 or expanded in 2013, but it's actually sometimes defended as well. And so there was a divisional court in a case that it's not really important. It's Belhaj and Budkar versus Director of Public Prosecutions. And so it's a case from 2017 where a divisional court says the court claims there is a paradox in the use of these proceedings. It actually says that the opposite. Quote, "The effect of the extension of the Justice and Security Act of 2013 to proceedings such as these is that the executive, in the form of the prosecuting authorities, can be held to account by the judicial process. What is described as an encroachment on their fundamental right is in fact enfranchises informed and detailed scrutiny by the courts, which would otherwise be impossible." So they are spinning it so that it's actually a good thing, because the courts can do a more proper job, which is weird, because why should...
Well, that's not wrong. If you give the court excessive power and secrecy so they can't be challenged, then yeah, I'm sure they can do a more effective job, but that's not the concern here, is it?
Exactly. I mean, informed and detailed scrutiny is not something that I would put like on the same level as like the secret courts or courts with secret evidence. It's a weird spin, and but it's kind of expected, because this court is basically promoting itself. It's saying give more powers to the courts. We'll have more powers. It's gonna be nice, right? So then, you would expect that exactly. So as well as anyone else and everyone, you could expect them to promote their own interests. The courts do that as well. And so I want you to like view this from like a broader picture. So this statement in particular, this kind of argument from the divisional court, that courts are a branch of the state, right? So they are instituted by the state. They are projects made by laws, basically, and they are often funded by the state as well. And so it makes sense that they will favor the state in where they're the party of the dispute. And it's kind of weird as well that in kind of private affairs, it would be unthinkable to have a party being a judge in its own case, right? But when the state is one of the parties, it's considered normal. That's really weird. So you shouldn't expect courts to back the state in most cases and have a consistent bias towards them, because simply you don't bite the hand that feeds you. Well, the EU Parliament actually agrees with the sentiment to a certain extent, because it says, quote, judicial authorities across the EU member states under examination have a high degree of trust in claims made by governments and intelligence communities in judicial proceedings that national security is under threat. And so they say that basically the evidence, or quote-unquote evidence, that is brought forward by the security agencies and intelligence agencies is being believed. Believe all evidence. So that's
well, I look forward to being able to challenge it.
Yeah, and so this is basically the standard. So when the divisional court in the UK says that it allows more informed and detailed scrutiny, it actually does the opposite, because the evidence shows, and the EU Parliament actually says, that the courts consistently tend to favor the state and the security agencies and not the defendant. And so now we should probably bring it back a notch and actually consider and realize that this whole time what we're discussing, we're talking about supposedly developed states, not some North Korea style tyrannies or anything like that. So this is all happening
this is sounding very South American.
This is all happening in modern Western liberal democracies, right? So this is the context. It's not some tyrannical regime somewhere in the butt of the world.
It's a tyrannical regime here.
Yes.
This is just awful. I mean,
so we're ending on a grim note, but that's basically it.